And who said their case was, that they have an active case?
Abraxas Megistus, James Holland.
Okay. That's what I thought. I just wanted to make sure.
Yeah.
And tell everyone what your case involves.
Traffic stop, the citations for speeding and for no insurance card.
In what state?
In Arkansas.
Okay. And you've read the statutes I sent you in Arkansas?
Yes, sir. I sure have.
Okay. And have they changed from what they said when I originally wrote the article I put them in?
They do not appear to.
Okay. So what's the question then?
Well, I'm still just waiting to hear back from the prosecuting attorney from the mail that I sent, asking him that question, how he intends to, basically the same thing that you wrote. I have to pull it up here again. Let me open that email real quick so I'm not misquoting myself or you.
Find your stuff yet, James?
I did, yeah.
Okay.
So filed the written motion for discovery, citing the statute that you gave there, which was the 23-2-201 definitions. Transportation means the carriage of persons and property for compensation by air, rail, water carrier pipelines, or motor carriers. And I still haven't got an answer back from his office, and the clerk's office can't answer me whether they're trying it as criminal or they're trying it as civil. But everything, it appears from looking online that it should be a criminal.
Well, if they've got it labeled as a misdemeanor, it's criminal. If it just says offense or violation, it could be either. But if it says misdemeanor, it's absolutely criminal, because there's no such thing as a civil misdemeanor.
Okay, let me look at this. I got the court date extended out to March 17th. That's the one thing that I was able to do. And on the notification of court date, it doesn't say anything on there either. It just has the case number and says it on offense. It just says no liability insurance. It doesn't even have the speeding on the extension of the court date. But the citation itself has both the speeding and the no liability insurance.
Well, the key thing you need to remember is that anytime they try to use the transportation-related terms, you need to object to it.
Okay.
If they call it a motor vehicle or a vehicle, or you an operator or a driver or any of those things, those are all terms that are written into the code as defined for the purpose of regulating transportation. Therefore, until they prove the context of transportation, those terms are inapplicable, because one relies upon the presence of the other, first and foremost. Absent transportation, there is nothing for them to regulate outside of criminal conduct. And that criminal conduct must be one that you can legally commit. And unless you're engaging in transportation, you cannot legally commit transportation regulatory misdemeanors.
Okay. I guess
it's like you fishing in a pond in your backyard and the state trying to charge you with violation of a commercial fishing statute.
I guess in this, the only question that I have is, so this is in Title 23 of Arkansas Code, and the actual statutes as far as the transportation itself is in Title 27, and it does say in this, as used in this subchapter, unless context otherwise requires. So it's this subchapter of 20.
Does the definition limit its applicability only to that chapter?
It says definitions and as used in this subchapter, unless context otherwise requires, and that's all that it said.
Yeah, unless context otherwise requires. Therefore, any other place they're using transportation as a terminology,
okay,
and they haven't created a different definition for it, then that one is binding.
Okay, there is no other definition of transportation.
I know that.
Anywhere in Arkansas.
That's correct, and there's a reason for that. Also, when you find the statutes that says that they adopted Title 49 then anything they do in the regulation of motor vehicles, commercial motor vehicles, operators or drivers, still is tied to Title 49.
Yeah, and Title 49, Arkansas only took on a few of the Title 49.
As did Texas, but regardless of that, they're the same in every state.
Okay.
Okay? And the thing about it is they can't rely on the federal law and ignore the federal definitions that govern that law. So even if the number of the federal law, the chapter, section, or whatever that contains the specific definition we're arguing about is not referenced in the statutes adopted by Texas or Arkansas, that's irrelevant, because the federal law they're relying on did adopt those definitions.
Okay.
And the state law says that it is adopting the same applicable definitions and meanings and interpretations that the federal law has. So that by reference expands the statutes it will encompass at the federal level to include the definitions the federal statutes rely on.
Okay, and to familiarize myself with that, I need to look at definitions under Title 49.
Yes.
Correct. Okay.
Under those specific sections of Title 49, and then find the definitions that govern all of those sections. Now, the one thing about federal law is federal law will create multiple definitions of the same term across many different places. So you need to make damn sure that the one you're looking at and relying on relates to the section you're using it for.
Okay.
I mean, that's one of the biggest things about their usage of the term state and United States. It means one thing in this section, it means a different thing in that section, and it means something else in this section. Even though all three sections' definitions contain terminology that overlaps, there will be at least one single word, and that word can be an or an if, that would change the meaning of the definition. Okay?
Okay.
So you got to understand, you have to read and comprehend every part of it in order to make it right. In other cases, that separate definition may contain something in addition to what the other definitions encompass, which again changes the definition. That's why you have to be certain the definition you're referencing does apply to the section that you're also using it for. And that's something all of y'all need to take into consideration when you're reading law.
Do you already have a document for Title 49 with all the breakdown of this information that you've compiled, or?
I do, as far as it relates to Texas statutes.
Okay. Is that something that you could share so I can cross-reference it to Arkansas?
No, because it's part of the seminar book.
Oh, got it. Okay. How's that coming along, by the way?
Slow but steady.
Yeah.
At least now I've got Chat GPT configured to be useful for something.
You trained it?
I use it to do my editing instead of having to send it off and wait for somebody else to give me feedback. The reason I wanted you in here, Helen, was because I need you, one, to send me a copy of the complaint dealing with the headlamp. I've got the one dealing with the failure to ID, but I don't have one.
I know what you're talking about. I'll send it to you. It'll have to be, the latest is in the morning, but let me see. I have the copy here. Let me see if I have it on my desktop too.
Okay. Well, the reason is because the complaint specifically states, or at least the one I remember us looking at specifically states, I don't know why I can't find it in the documents we have saved for you, but it's sure as shit not there. But anyway, the complaint specifically says that the statute or that the charge is failure to maintain 2 operational headlamps. Well, the state has to prove the statute requires that. Okay? So now you get to force them to introduce the statute as evidence of the claim made in the complaint.
Okay. Next week is the pretrial hearing, so this is perfect information for me to add to my outline.
Okay. But they're going to have to try and introduce the statute or get the court to take judicial notice of the statute themselves. But their problem is they're not going to be able to introduce the statute as actual evidence. But the law is very clear that the complaint must prove what it asserts. The state must prove what the complaint says, and they must do that through admissible evidence. The officer's opinion of the law is not evidence.
So basically, that's the full, right there, just that sentence is basically the summarization of that complaint. The officer's opinion is not the full evidence that's required within that complaint. He has to state every single...
Well, it's a little more than that, but the thing is that's not really part of your... It's part of your defense, but it may or may not necessarily be part of your pretrial. The point here being that the officer's legal conclusion or even his professional opinion is not evidence of what the law requires. Period. Therefore, the state must prove that the law itself says what the complaint claims it says, and that they cannot do.
But you know, and I know they're going to try to do it in one way, shape, or form.
They're going to try to say, okay, I'll tell you exactly how they're going to try to do it again, just for the record. They're going to start with Section A of 547.302. And for those of you that are here in class, I'm going to share it up on the screen so you can follow along and see what we're talking about and why reading and understanding the statutes you're being charged under are so important.
Hey, send Jane the link, by the way. She said she wants to attend.
Well, I put the link in the chat. I don't know if you got it or not, but I'll put it in there again, just so you can have it and send it to her. Jane should have got the link. She's still on the email. She's showed as unsubscribed, but she's still on the mail list. Okay, anyway. A vehicle shall display each lighted lamp and illuminating device required by this chapter to be on the vehicle. The operational word here is shall display each lighted lamp and illuminating device. Okay? The problem here is they're going to try to interpret that means that every light has to be on, or every headlamp has to be on. But that reading would require that every single lamp be on and illuminated, even the turn signals, because they are part of the each lighted lamp requirement. As we had stated, there's 7 different types of lamps. Correct. And each one is required to be installed on the vehicle. Yeah, thus they are displayed on the vehicle. But they are not required to be illuminated just because it's after dark. Right. Okay? Right. Okay, so, and number 1, and it has to be done at nighttime and when light is insufficient or atmospheric conditions are unfavorable so that a person or vehicle on the highway is not clearly discernible at a distance of 1,000 feet ahead. Now here's the problem with this section of this statute. There's no requirement that a person be equipped with these lights. Therefore, how can the statute require that a person be clearly visible and discernible at a distance of 1,000 feet ahead? All they're talking about is the vehicle in that stance, correct? Well, no, they're saying so that a person or vehicle on the highway. But now, how is a person supposed to be illuminated? Well, exactly. But here's the other point to that. There is no light on any vehicle short of a spotlight which you're not allowed to use while you're driving, that can shine a beam 1,000 feet ahead of your car to illuminate objects at that distance and make them visible and discernible. The only way that could happen is if the object itself is reflective enough or bright enough to be seen from that distance through that lamp, like a reflective vest or their own source of illumination, such as lamps or taillights. But no vehicle is capable, has a headlamp that will show a target at 1,000 feet ahead in the dark. Okay?
Yeah, that makes perfect sense in my brain. Now, another question.
This goes to our argument that the illumination requirement is so that the vehicle emitting the illumination itself is visible from 1,000 feet.
Yeah.
That's the argument we made in your motion to dismiss.
Yeah, right here. Texas law does not mandate that both headlamps be operational at the same time. In review of the charges against me, the statute, which is current as of April 4, 2021 at that time, 547.302A indicated that a vehicle shall display each lighted lamp with an illuminating device required by this chapter to be on the vehicle. 1, at nighttime. 2, when the light is insufficient or atmospheric conditions are unfavorable, is that a person or vehicle on the highway is not clearly discernible. And now we're arguing, okay, well, then a person can't wear a spot lamp in order to be seen.
No, there's no requirement that a person be carrying or wearing a lamp in order to be seen.
Okay. And then...
because A specifically says that this applies to a vehicle.
So where did they get person into that statute?
Well, therein lies the problem. Okay? They're claiming that the vehicle that's emitting the light must make the person visible. And that is physically impossible because we don't make such a light in the form of a headlamp.
At least one lighted lamp shall be displayed on each side of the front.
That's C.
Nowhere in the statute.
That's our counter. That's our counter to A.
Right. Nowhere in the statute is a headlamp defined, much less no requirement is mandated for both headlamps to be illuminated at the same time. That would be my main argument right there.
Yeah.
Legislature would have made the language clear when creating the statute to make it required within the construction of the code. For there to be a valid complaint, all of the elements must appear within the complaint. Sergeant Howman's complaint does not indicate the atmospheric conditions nor the measurements in feet at which he was unable to identify my car on the roadway. The complaint defective equipment does not appear in the Texas Transportation Code. That's what I have right here in my notes.
Right.
And then we went in further, and we went to 547.333, multiple beam lighting equipment, and we went through each of the elements.
Yes, we did.
And so we talked about it. We said, A, unless provided otherwise, a headlamp, auxiliary driving lamp, auxiliary passing lamp, or a combination of those lamps mounted on a motor vehicle other than a motorcycle or moped, 1, shall be arranged so that the operator can select at will between distributions of light projected at different elevations, and 2, may be arranged so that the operator can select the distribution automatically. At least one of the beams was working sufficiently on the passenger side for both high and low beam, and on the driver's side, the lower beam was operating at the time of the traffic stop. If none of the lamps were operable, then the officer would have not viewed my car from any distance. B, a lamp identified by subsection A shall produce 1, an uppermost distribution of light or composite beam that is aimed and emits light sufficient to reveal a person or vehicle at a distance of at least 450 feet ahead.
Correct. Stop. That right there completely destroys the 1,000 feet that we're talking about up in 302. Right here it says
So
that
this is what I need to highlight then.
right.
Highlight
That the light emitted from the vehicle itself must go at least 450 feet. But there is no guarantee that it can or does go further than 450 feet. And this is a specific provision that overrides the general statement made in 302 of 1,000 feet.
Okay, so right here I'm going to make a note that we need to use this. This overrides the 1,000 feet provision.
Right, and see,
under
that's
302.
the uppermost. In other words, your high beam distribution of light has to go at least 450 feet, which is less than half of the 1,000 feet in 302.
And that's the upper half of the beam, you're saying?
Uppermost distribution of light, that's high beam mode.
Distribution.
A lowermost distribution of light is low beam mode. That's it
Which
too.
blows apart.
And that's at least 150 feet when it's in low beam. So all we can definitively say is that the law requires it to not shine less than 150 feet to at least a maximum of 450 feet. But it cannot require light up to 1,000 feet.
Okay, let me see. So
Despite what 302 says.
Yeah, a lower distribution of light or composite beam that A is aimed and emits light sufficient to reveal a person or vehicle at a distance of 150 feet and is aimed so that part of the high intensity portion of the beam.
No part of the high intensity portion of the beam.
So that no part. Okay, so no part of the high intensity portion of the beam on a vehicle that is operated on a straight level road.
Right. In other words, it can't be, the high intensity can't shine straight ahead because it will blind other drivers.
Mm-hmm. Oh, okay.
Okay, that's what B says.
Blinds other drivers. I'm just making notes on this.
And
so
this section here is what gives us the argument that the 1,000 feet requirement is that the vehicle emitting the light itself has to emit enough light so as to be visible from 1,000 feet. That's where the 1,000 feet argument is made and how it's made.
Mm-hmm. But in reality, the uppermost is 450 feet.
No. Listen to what we're saying. The vehicle itself must emit enough light so that it's visible to someone else in a different vehicle or a different person walking around from at least 1,000 feet. But the person in the lighted vehicle may or may not have visibility between 150 to 450 feet.
Okay.
You understand?
So the vehicle is visible to others at least 1,000 feet, but to
Correct.
us inside the vehicle, we can only
the maximum is 450 feet that we must be able to see ahead. That we must be able to see other persons and objects in the road.
Persons, objects,
or vehicles, assuming the vehicle has all of its lights off.
At least 100 or 450 feet. Okay, I made that note right there.
Yeah.
And then those that are the 1,000 feet requirement then comes
the easy way to do it is very short. The 1,000 feet requirement is to ensure the vehicle itself can be seen from at least 1,000 feet away. The 450 foot requirement is how far the operator of a lighted vehicle must be able to see in front. And the minimum distance is 150 feet in front. That's it. That's the argument on both points.
150 feet. Now, let's play out this scenario. They're going to try to say Oh, well, we couldn't see you at 1,000 feet. Now,
Then where's your proof of that?
where's your proof? Where is the state?
How did you measure the distance from where you were sitting when you first saw my car to where you were? What was the actual distance? Where's your proof that you measured it? It was
and
dark.
There's no way for me to prove
you
it.
you had no frame of reference for landmarks or anything else because it was nighttime, correct? And you must make damn sure you set that up. Make sure that's strictly in the record. You issued this ticket at nighttime, approximately this time of night, correct?
12:30 a.m. Correct.
Okay. There was no sunlight.
No.
Okay, but you said there were street lights, right?
Oh yes, and they were all illuminated,
Okay.
including the business lamps.
Okay. And so, where is your evidence proving that you could not see my car at more than 1,000 feet?
Yeah, because it's not in the complaint. And I'm thinking back to the Judge Fleischer. I've been sitting and listening to how he, throws out a lot of probable cause. And the officer what? And, when he gets to that point, it's like.
Right. Well, that's when the complaints are incomplete and the reports are incomplete.
And this complaint report
right
is
now,
no different.
that's exactly one of the problems they're having.
And this is what we're seeing with this complaint.
But now understand that Fleischer is going to be operating under the same presumption they are, that because the state requires 2 headlamps, then they both must have to be lighted.
But that doesn't say that in the statute. Prove where it says
That's correct. The state is alleging in the complaint that I was not displaying 2 lighted headlamps, yet the state cannot demonstrate where the statute makes any such requirement.
And that right there is the full summary of that. The state isn't able to prove where there is such a requirement for the 2 lighted headlamps to be illuminated at the same time within the statute. It's not there. It's not there. So that blows them in the water. Now I'm waiting to hear, okay, here's my question. My question is, after it's been about a month, as of this weekend, about a month since I sent in the constitutional challenge. Typically, in your experience, how long does it take the OAG's office to respond to such a challenge?
Well, I don't know. I've never had them do it.
You've never had them do a challenge?
They've never responded to one.
I see. So my odds of getting this challenge response is not 0, but not much of a percentage, right?
Well, the thing is, they're going to have a hard time saying that the statute's valid after it's been constitutionally challenged and no one defended it. That's what the AG is supposed to be there for. If you're challenging the constitutionality of a statute and the AG doesn't come and defend its constitutionality, then the presumption must be that it's unconstitutional.
So no answer is more than likely stating that it's unconstitutional.
Well, we can make the argument that that's the case.
Mm-hmm. And this could be a possibility as to why, I don't know if it's the true possibility, but it's a high possibility why a lot of lawyers don't make these challenges. Because
it's entirely possible.
Because at the office that I went to, I mean, they acted like they had no effing clue what the hell I was asking them to do. So they thought, oh, well, we just take in things we don't send out. And I'm like, no, right here, texascourts.gov. Here's the form, and here's the requirements on the form. Here's the instructions. And here's what's to be provided. Once this one woman took it to the very, very top boss, they fulfilled it, but they'd never seen that before. They have not
Right.
been trained.
Yeah, and that's the thing. This
So-
is what I tell you about. If you think the people that are supposed to know the law do, you're
They
mistaken.
They don't. And they're not being trained.
And if
there
you
must
think
be
you know
some-
what their job is, they
They
don't.
don't. No, they have no effing idea. But there must be, to me, it sounds like it's blatantly done on purpose not to train them to do
It
stuff.
is absolutely done that way.
Because, I mean, in the ethics of your job, now I'm going back to reading some things the past few days about the rules and responsibilities of the state as far as the prosecution goes. And their requirement for them is to see that justice is served, not to convict.
Correct.
But that's not what they're doing.
No. They
No, they're
always
not.
go for the conviction, even if it's unjust.
And that's
You
the
see
thing,
it every
and that's
single
why I
day.
fight. And that's
Because
why
the conviction is revenue centric.
Right.
It is not justice centric.
No,
It
it's
is
not.
never justice centric.
So it's basically debtors like
No, it's to create debtors.
create debtors. But that's what I mean to say. They're creating debtors, and it's a burden on society to vote people in like that.
So is government in general.
So the last class that we were in, my internet cut off because I was in vacation in Central America, so we had drove off from the free Wi-Fi. But you had mentioned that I need to write a brief for the constitutional challenge for the pretrial.
Well, we've done that. You already
Huh?
have one of those.
We do? We have one?
Right here, challenge the constitutionality of a state statute.
Where is it?
Is that the... Oh, okay, I'm sorry. That's the form.
Yeah, that's the form. You said I needed to write a brief based on everything that I've already submitted to the OAG.
Right.
So what needs to be in the brief? Just a summary of that, or?
Well, okay. What did we say the constitutional arguments are? With what statutes?
Okay, so within that, let's see, I've got it in here. Let me pull it up. So we said Texas Constitution, Article 1, Sections 9 and 10. I recall that. And if I'm not mistaken, we talked about the Fourth Amendment to the United States Constitution.
Well, no, wait a minute. I understand what we're using as a reference for unconstitutionality. What I'm asking you is what statutes are we arguing are unconstitutional and why?
Oh, that was in under the failure to ID. So
Right.
they use 38.02 from the Texas Penal Code. Is that correct?
Correct. 3802, the new subsection.
Subsection. That's where I am.
Yes.
And so I have that here in the motion. Let me go through it real quick. Yeah.
Yeah, I'm pretty sure the motion makes that argument.
Yes. The initial seizure of the defendant was not lawful. They lacked articulable probable cause. Without a codified offense, there can be no reasonably articulable observations and facts. Okay, that was one. All right, here we said, at what point does an officer's inability to disregard to practicably know and understand the statutory laws become transformant as a mere mistake? So we went through that. Then we discussed, can view thousands of videos, blah, 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 the first, second, fourth, fifth, sixth, 14th amendments. Then we went into more detail. We needed to see here. And here, when an officer acting under color of law is allowed to make a mistake of law, we discussed that under Article 2, Section 1, State of Texas Constitution. Article 3, Section 1, the State of Texas Constitution. Neither the courts nor officers of the executive branch of our government can legitimately make law. And right here, we went to the Penal Code at 39.02, an official oppression, 39.03, an official misconduct pursuant to Article 3.04 of the Texas Code of Criminal Procedure. So regardless of what the United States Supreme Court rules regarding an officer's mistake of law at the federal level, the state of Texas level, an officer's mistake actually results in commission of several criminal offenses against our state constitution and laws, and neither honest ignorance nor professional incompetence of the laws excuses criminal conduct, even when the conduct is perpetrated by a public official. Furthermore, any violation of Article 2, Section 1 or Article 3, Section 1 presupposes a direct violation of Article 1, Section 29 of the State of Texas Constitution within our Bill of Rights.
Yes.
Is that correct?
If that's what it says, I don't know why it
Yes,
wouldn't be correct.
that's what we have. That's exactly what we have. And we went in, and you went into every single element of that.
Hence the reason I say, don't we already have that?
Yeah, we do.
Okay. Now, Sandra, I'm sorry, go ahead, Ellen.
You said, furthermore, currently written, the particular requirements and offenses defined under 38.02B1.
Furthermore, as currently written?
Yeah.
Okay.
The 38.02B1, which is what they use, Penal Code, or Section 521.025, are unconstitutional, and that such provisions singularly subject those individuals and only those individuals who are allegedly acting under the alleged privilege of being in operational control of an alleged motor vehicle to the mandatory waiver and outright surrender of specific constitutionally protected fundamental due process rights.
Yes. That's a very important part of that argument.
Yeah.
In fact, it's
Definitely
one of the most important parts of that argument.
Right. Defendant in error was not operating or driving a motor vehicle, as defendant has read and understands the individual and imperi materia meaning of these specific terms of art as used within the aforementioned statutes, a statutory meaning that the state has merely presumed to be applicable in truth. Yep. We got it.
Okay.
So that's going to be the arguments I make as far as that's concerned, correct? As far as that brief?
Correct.
And what we challenged.
Correct.
Okay, perfect.
All right, Sandra, anyway, you emailed saying that you had some questions you wanted to ask tonight, so please go ahead and do so.
All right. I had a small claims, I was a defendant in a small claims court today, actually, and I as prepared as I tried. And what happened was, the situation is my sister owns a car and she took it into a repair shop for a annual inspection in January 2025. She just pulled the car off the property and the engine blew up. Because I'm a twin and I have a Sandra and a Sandra, they served me with the documentations in small claim court, because what I found out is that the auto dealership didn't have, per Florida statute of the Motor Vehicle Act, did not have a reference number from the Department of Agricultural and Consumer Services. They were operating in violation of that.
Well, wait a minute. Which applies to what aspect of their business?
Motor vehicle repair.
Okay, but you were there for an inspection, not a repair, right?
Okay, originally that was we took our car, when I say, because I'm a twin, we took the car in for a general annual inspection.
A maintenance inspection or a vehicle registration / insurance inspection?
Just
We're
regular
talking two different things here.
a regular maintenance inspection. There wasn't really anything wrong with the car, but we live out in the country and we just
Okay, so what everyone would normally refer to as a tune-up inspection.
Yes, exactly.
Okay.
So the plaintiff was a lady female that represented a company that she owns, and then she was a single individual lady was representing to a business that she owned for another business which was running as that did not have a registration to be a motor vehicle repair. Okay, so there's a lot of things that went wrong, even though thought I was prepared. The judge didn't allow me to even write a defense. He had the plaintiff explain the car dealership or the faultiness of the car or the supposedly repair, and they went into great detail with that. And I wasn't allowed to interrupt. Of course, I know I should have said, objection, which I did file objections in this whole court. And I'm getting off track a little bit. So when it was my time to give the facts that it was the person who, or the company that was supposed to do the repairs on the car was not registered with the Florida Department of Agriculture and Consumer Services, which is in violation of the Florida statutes. She have no standing to be an individual to represent a business, to represent another business. I wrote that as a motion, motion like not having standing, motion to dismiss, and other numerous things, right? When it came to the small claims class, the judge let the plaintiff just go on and talk, and then I thought it was like my turn, but then the judge said, well, this has gone on. This case has gone on too far, and I've devoted too much time, and so I'm making verdict for the plaintiff, and then left.
And you appealed it, right?
That's what
he can't do that.
Right. I'm doing that as we present, and so we're going to move it into civil case, and that's where I'm at.
Okay. Well, the next thing you need to do is file judicial conduct complaints on that judge.
Exactly, because way out of line on so many different cases. Way out of line. And like you said, I'll tell you one other thing that they pulled on me, which I swear to God, like I said, I work, so sometimes like I have not been really that sharp and I haven't had any issues. I was served the complaint with exhibits with it. Okay, I went back to the clerk of court, which is digital, and I said I want to do an audit to make sure that everything is in line with what I've got. So they said, yeah, you have a complaint, I have a complaint, such and such. But what happened was the exhibits that I was served by the process server weren't the exhibits that was filed with the clerk of court. And I brought
Okay, then that's an objection for violation of discovery. If they were supposed to serve you with specific documents that they had filed with the court as discovery, and what you received was not the same documents, that's a violation of discovery.
Right,
and I should have lost them the case right there.
Right, and I filed inside. I knew that because, like, I've been with you guys. I filed a notice of discovery. I asked for a notice of discovery that was going to be, for court, and they didn't answer at all. No, I got nothing, and so not only did the plaintiff have no standing, not only did they not have registered with the Florida Department of Agriculture and Consumer Services, not that I didn't get a chance to cross-examine, not that I even got a chance to talk, and when I come to find out, because like the judge was talking about some like transcript, I'm like, what transcript are you talking about, right? And he says, he didn't, like I'm saying, like where, I need a copy of this transcript where you're talking about. And he ignored me, right? That's another objection. But
well, each one of those is a separate complaint in a judicial conduct complaint. Each one of those ways he failed to give you due process and to comply with your rights in that courtroom is a separate complaint.
Exactly. And I'll file
Okay.
this. The thing is, right now, is I am going to move it. I'm going to move it to civil, right? Appeal it. This case was today, and I thought it was simple, right? Because I was prepared for it. I filed the documents. I was really good at filing documents.
Well, even you said you thought you were prepared for it, but you weren't.
Yes, exactly. I just didn't expect.
So learn from today and apply it correctly and get better prepared so that you actually are.
Yeah. Okay. This is the idea, right? And let me see where I went wrong. I called, I was emailing the Florida Department of Agriculture and Consumer Services. A motor vehicle repair shop has to be registered with them to operate legally in the state of Florida. But there was no registration, so I asked.
Okay, well, let me stop you here for a second.
Okay.
Which company of the two you're talking about? You say the lady owns one, but she was representing another.
Yes.
Okay?
Okay.
Which company was the one that was suing you?
Yes.
No, not a yes. Was it the company the lady owned or the other company that was supposed to do the repair? Which one was suing you?
Correct. Okay. I understand, and you're sharp. You're really sharp because you picked this up. The plaintiff filed the complaint by suing on behalf of the business, and you got to take it, Levy County Tire Recycling LLC. That's what the complaint said the plaintiff was.
Okay, wait, stop. That doesn't tell me which company that is. Which of the two companies are we talking about here that was the plaintiff?
The plaintiff with Tire Recycling. That was the plaintiff.
Which is the company she owns or the company that was supposed to do the repair?
Okay. On the complaint, she officially owns, and on she officially owns the Tire Recycling. What she does is she also, this is not a non-entity, but she also is working under Levy County Tire and Auto Repair. But Levy County Tire Auto Repair is not registered as an auto repair.
I got that.
Right. And she...
Which one was supposed to fix the car?
Well,
there is no well. There's an A company or a B company.
Levy
Which one?
B. Levy County Tire Tire and Repair.
Okay, they're the ones that were supposed to fix the car.
That's correct.
Okay. And they
did not have
the other company is the one that filed suit against you for what? Or against your sister for what?
Against me because I paid by a debit card. $2,233.
To the Levy County.
Yes, Tire and Auto Repair. And then the car, like you said, then the car, right, well, my sister picked up the car, the engine exploded, and the engine was dead. I mean, it's unrepairable.
Okay,
So,
did you have it inspected after that? The car?
Yes.
And was it determined that all the oil had been removed from the car?
Yes.
Okay. So that's negligence on the part of the company.
Yes.
Okay. But they're suing you to recover the money that you paid by debit card and then had the debit card canceled.
No, I didn't. It was not canceled. I filed for fraud. It went through the bank. Well,
that would be canceling it if they refunded the money.
Yes, they refunded the money.
Okay.
The bank did. The bank fraud division refunded the money.
And then they turned around and sued you to try to get the money back.
That is correct.
Okay. But the lady who owns both companies, one of the companies isn't registered.
That's correct.
Okay. So, which company was named as the plaintiff?
Recycling, the company that didn't do the repairs. The Tire Recycling.
So, right there, there's a problem.
Yes.
That company lacks standing, which you noticed, and she lacks standing to represent the other company in the name of this company, even if she did own both.
That's correct.
Okay? Because they are, for all intents and purposes, separate companies.
Correct.
Okay. So, the judge should have thrown it out on that alone and
Correct.
didn't. So that's a judicial conduct complaint.
That's
The
correct.
judge refused to hear arguments challenging standing of the plaintiff,
That's correct.
despite the plaintiff being a company that did not perform the repairs or accept the money.
That's correct.
Okay? And therefore had no standing to file suit.
That's correct. And I filed that as a motion to dismiss, and the judge denied it. And then I filed an objection, and I said error upon appeal, because they're still going ahead.
No,
with the
appealable
case.
error.
Yes, comparable error.
Okay? But
Yes.
but appealable error is not the basis. That's what it is. But the basis is abuse of discretion.
Okay. I haven't got that yet.
The judge abused his authority and his judicial discretion by not applying the law to the facts.
That is correct.
In fact, from all appearances, the judge could give a shit what the facts are. He had a predetermined outcome in the case, which itself is a separate complaint.
Okay.
So now you're up to 2.
Yes.
Then the judge prevented you from making a defense. That's violation number 3. The preventing you from making a defense is a violation of your right of due process, substantive and procedural. That's violation number 4.
Yes.
Okay? The judge demonstrated partiality to one of the defendants. That's violation number 5.
Yes, that's true.
The judge cast the judiciary in a disparaging and, let's see, what's the proper terminology? In a disparaging and unfavorable light. That's violation number 6. And number 7 is he eroded the confidence in the judiciary by acting as a proponent for one of the parties.
Yes, that is true.
Now, here's something you might want to consider doing just for the hell of it if you've got the money to do it.
I do.
Get a private investigator to investigate that judge and their relationship with that lady and or her companies.
Yeah, that crossed my mind. I mean, like, there was definitely a partiality.
Well,
because I wasn't
but
given
the best thing you can do to make a case for suing that judge is to prove it.
Yeah. But that may be tricky. I will entertain to try to do that. I don't know, like, what the outcome could be, but
Well,
yeah.
you never know. That's the whole reason why an investigator is required. But the problem is that in most states there's a law against you doing any investigation that's going to lead to a court case based upon the evidence you get. Now, it's one thing to use that evidence to report a crime. It's another thing to use it as evidence to sue or to turn over to for pay or profit. And if you're using it to sue, that's what they're going to try to argue you're doing.
If I investigate versus the private investigator.
Correct, because most states require a license to investigate to gather evidence for those purposes and get a financial benefit from it.
Right, I got it. And then, like you said, the case was just this morning at 9 o'clock. So, given that today, I'll file notice of appeal and then file the, it's like $300 to file an appeal from small claims to civil.
You've already paid the filing fee for small claims. Why would they turn around and make you...
I was the defendant. I didn't pay anything.
Yeah, but you're on appeal. You don't pay to get your appeal. when you're the defendant?
Well, I've been told I do, that I have to pay $300.
Who told you that?
The clerk of court.
Okay, well, then you need to check with a higher court and see if that's true.
Okay.
But if you're appealing the judgment of that court, I don't see how they can make you pay for the appeal.
Yeah, well, like you said, I've been out of this for a while, but the clerk of court said that I have to.
Is this the same clerk that works for the same judge that don't know the fucking law?
Pretty much.
Well,
yeah,
then I wouldn't take anything that clerk says as advice.
Right.
Or as
like
truthful.
Said, right. I live in a very rural, a very small, live in a very rural and very small.
See if you can get what they're using in writing to make that
ruling
determination that you owe based on an appeal that you're making in that court on their error. I would get in writing.
You wouldn't make the appeal in that court. You would make it to a higher court. That's the whole point.
Yeah, but you need to find out what statute they're relying on to go through that, or which rules they're using. And then you need to investigate those rules to see if that's actually what the law.
I have 10 days. Supposedly, I have 10 days to do that.
Right.
I'll file
well,
notice.
make sure you understand whether that's 10 business days or 10 calendar days.
Exactly. And tomorrow's Saturday and Sunday. Just to be on the safe side.
They can't count it if the first or last day falls on a non-business day. But they can count them if it's in between those dates.
Okay. I had the case today, and tomorrow's Friday, and then we have Saturday and
Right.
Sunday.
So the counting will start tomorrow.
Yeah.
If tomorrow was Saturday, it wouldn't. But if it's now, that's the way it is here in Texas. I mean, in Florida, it could very well be different. So you need to make damn sure you know what the appellate procedure is and what the time frames are.
Understand. I will turn in right before 10 days of any calendar day.
Yeah, here your best bet is to always assume calendar days.
Correct. And also too, like you said, the complaint that I was served is different than the complaint that the plaintiff turned in to the clerk of court. And when I went back to the process server, they also said that they're not responsible for that. That the plaintiff just gives the complaint to the process server, and the process server serves it without knowledge that.
The process server is not responsible for what's in the service.
Yeah.
Their only job is to serve what they're given.
Right. And so they gave me, again, I wasn't sharp enough because it's been time elapsed. I mean, like I said, the last time I talked to you was in 2021. So I wasn't sharp enough because you guys have told me, you got to go look in the file. But I work, and it just didn't, it's in the back of my mind, but I wasn't sharp enough to do that. And so what they served me wasn't the same as what they put in the file.
Right, and the problem is that can come back to bite you in the butt if you don't challenge what they actually filed versus what they actually gave you. Now, the problem there is if they're required to respond accurately to a discovery request and they fail to do that, then you've got a leg to stand on. But if there's no requirement that they serve you with anything for discovery, if you didn't specifically request it.
I did request it.
The thing is did you request something specific that you didn't get, or did you just make a general request that could have encompassed anything?
I covered everything. I said documents, I said video, I said everything. I said everything that's going to be used in trial, I would want a discovery. So I purposely
never ever say that.
Okay, what?
Never ever say everything that's going to be used at trial. Never ever say that. Because they're never going to use exculpatory information at trial. And the exculpatory information is exactly what you want. Never ask for discovery that way. Ever.
Okay, well, I okay, I have it with me, but I promise you I probably did 2 lines. I said I put 1 line of documents, video, and named everything they could think, and then I put another line that said in everything that to be, I have my file, but I won't waste your time, but I probably put, I probably itemized everything that they could, use or put for discovery. And then I also probably put another line and said, and everything, and anything, right, to cover everything. But I was descriptive on requesting it. But I did request it. And I wasn't given any discovery at all. And the exhibit that was given to the complaint, right, they did not file that with the clerk of court. But they filed something else, completely different than what I was served.
Well, again, that goes to checking the court record.
Yes,
something else you cannot fail to do, and that right there is a perfect example of why.
Yes. To tell you the truth, it didn't. It's been a while, and I know because you guys know me from way back when. At the court system, they knew me really well. That I wanted to look in the file, and I just didn't. I just okay. What do you say? I wasn't sharp enough. I forgot, and I didn't look in the file. But I probably would have got heartache because the Levy County in Florida, which is like northern Florida, I'm sure I would have they would have said, oh, it's digital, because we started to get that at the very end in the Brevard County, is that they weren't going to, back in the day, I used to fight with them. I wanted to look inside the real file, but they'll say, oh, no, everything's digital, you can't look in the file anymore, right? And then I had to fight with them. But it just didn't, so yes, that's an error on me. I mean, I didn't look in the file. It just, I could say that a million times. I couldn't believe that it could get this bad, but it went bad quickly. What can I say? So right now I'm at, I will, within the 10 days, I will file notice of appeal. I will check the Florida statutes and because it's small claims going to appeal, small claims. So the amount in question was $2,233, something like that. But they also, they blew up the car engine and it was unrepairable. So and also so now the other thing is to how to recoup money or damages from that. And that's where I have questioned everybody, oh, you can't receive any money. But if I appeal it, is there a way to get damages or anything?
Yeah, you can countersue. But you have to countersue.
That's outside of the appeals? I know we've come across that way back.
It is now. You should have countersued when they sued you. You should have countersued for the blown up car.
Honestly, yes, right? But I was working, and I was working...
Again, that's irrelevant.
Yes.
If you want to get your damages, then you're going to have to sue them.
Okay? Now, there's tricky things with that. The car actually belongs to my sister. I paid for the because it was just that I gave them my debit card because me and my sister are twins, so I paid for it. But the car actually belongs to my sister. It's registered under her.
Well, you have a vested financial interest in the car, right?
Yes.
Okay, because you paid for it.
Yes.
All right, so what's the problem?
So I can sue for damages even though, it's under my sister's name?
The money came from you to pay it.
That's correct.
Okay. So you can say that you and your sister are joint owners, even though the title's in her name. You're joint owners of the car. Let them make the argument that you don't have standing if they're going to make it. That's what they did to you, right?
Yes. There was my name is Sandra and my sister's name is Sondra, A and O difference, and everybody just automatically uses the A first, and it's like they always use me first. So they don't even acknowledge my sister.
Well, again, that's the other thing, is that the judgment was against the wrong person.
That is correct.
Okay, but that does shoot you in the foot on filing the suit, because now you're trying to separate yourself from the car and not be liable to them. So it's 6 of one, half a dozen of the other. If you're going to countersue, then you need to let them think that they served the right person and that they could sue you. If you want to get out from under that, then you're going to lose your ability to sue them back, and your sister's going to have to do it.
Right. Yeah. The complaint was that the complaint was that they were not paid for services. That was the complaint. It was just a check mark.
I understand that.
What?
But their services resulted in damage to property.
Yes, that's true.
And in order to recover for that, you would have had to have sued them.
That is correct. At the time, I was working, and it was $2,000, and at that time, it was really. It was. We just sort of, like, me and my sister decided it was just not worth the aggravation for the $2,000, and so we just, we said we'd probably eat that. But yeah, and then they sued me because, like, I got the money back from filing a fraud charge with the bank, and I received that money back. And so I just called it, okay, it's done and over with. And then like, what is it? 3 months later, then they sued me for not getting paid. But I paid them with a debit card. That's straight cash. And I went through the bank's fraud, thing. They had a right to make put their side of the story for fraud, whatever that was. But the bank ruled in my favor there was fraud because the bank, and I don't have privy to that, but the bank sort of told me that the title of the like I said, the other company. It's
not a properly registered business, therefore committing fraud by operating.
Exactly. Right. Exactly. And I thought that was so clear and crystal clear that I didn't have. I mean, I just thought it was so crystal clear.
Well, did you get something in writing from the bank to take to court with you to show them?
Yes, and I filed it as an exhibit. Yes, I did.
Which the judge never allowed you to present or looked at.
Yes, because at the very end, when it was my turn to put up my defense, the judge said, honestly, he got very fidgety, and then he really got anxiety, sort of like, and then he said, this case has gone on long. He said, this case has gone on long too far that I've putting any energy in. I filed for the plaintiff, and then he just exited.
That right there, that's judicial misconduct at its finest. So that's charge number 8 against the judge.
Yes.
Judicial misconduct.
And it was, again, my observation. He had no desire to listen to the truth. So that's what happened to me.
Eddie, can I ask a question about judicial conduct complaints?
Yeah.
So you mentioned a bunch of things in there, and I've considered filing them here in the 10th district with the federal court, but they explicitly say anything that has to do with the ruling, we will not consider. So you said lots of things, and the courts are definitely doing those things, not hearing the case, not hearing the facts, not applying the facts, things like that, but I don't understand how they can exclude.
The first place to deal with it is an appeal. Always. The appeal is what you do for the judicial decision part of what's going on. Once you've done the appeal and you now have something in your favor showing the judge did abuse their discretion, that's when you file the complaints. But you have to win the appeal.
Yeah, well, this is the appeals, and they won't even consider the case. So they're going through the motion of, looking like an appeal, but they're like in what this woman just said, they're not considering facts. They're just basically, for all intents and purposes, they didn't even read the case. And how do I have no way to remedy that. I have a couple other leverage points, but I was just curious what you meant, because you said some things that were pretty relevant there.
Well, what I would do is I would appeal higher than them if they're refusing to hear it.
Well, I'm going as high as I can go. But I was just curious about those conduct complaints. I actually filed a civil rights complaint today against the head judge of the 10th Circuit.
Well, that's a different thing. A civil rights complaint is something else.
Yeah.
But a judicial conduct complaint, that's a different animal.
I want to do it all at some point, but I just got prompted and I felt good about doing it. I was calling about something else, and they literally denied access to the court. They think they're not bound by certain laws, and because they do that, when it comes down to something, they will leverage against people, whereas lower courts, state courts, are not allowed to. They're bound by certain laws. So I just filed a complaint to see where it would go. But anyway, I was just curious what you said about those conduct complaints, because you mentioned itemized things that were pretty.
Well, the federal conduct complaints are completely different than the state level complaints. That you got to remember that.
In the way they are handled, who handles them?
The United States Supreme Court.
Well,
they're the ones that makes the decision.
The 10th Circuit governs themselves. They have an executive committee, and it's made up of a panel of judges. I'm sorry?
They handle the discipline of judges within their district, but the judges of the 10th Circuit are overseen by the Supreme Court.
As far as their ruling or their complaints?
As far as their administrative acts and their judicial conduct. But the thing about it is you have to petition Congress or the U.S. Attorney's Office to go after them for it, to impeach them or censor them for what they're doing. That's why the Fed's different than the state.
Okay. Well, I did talk to the U.S. Attorney's Office today. They're part of the Department of Justice.
Right. And what did they tell you about how to file complaints against a federal judge? Or a federal court.
They just took the complaint. They took the complaint right there, and she says, I give it to the attorneys, and they decided they're going to do something.
There you go.
So, okay.
All right. Anybody else?
Hey, Eddie.
Yes.
I'm in Utah.
On purpose?
Yes.
Okay.
Got a speeding citation on New Year's Eve, and I put the law in the chat. I was on my way to work in the morning. He said I was going 70 and a 60. So I was wondering what's the best first step to fight this.
Well, have you read the statute?
Yes. And Utah law is very vague.
What do you mean Utah is very vague?
I have it right here in front of me.
Well, don't copy the text. Don't copy the text. Copy the link to where you found the text. Put the link.
It was on. Yes, I know. I did. I went to the Utah's code, directly on their website, on the government's website.
Yeah, and then you copied the text of the statute and put it in the chat. Don't do
Okay.
that. Put the link to the statute in the chat so I can pull it up in a web browser here and make sure that I've got everything I need to see it.
Okay. I'll do that right now.
Okay? In other words, go back to the Utah code and copy the link to the section where you got this from.
Yes, I'm doing it right now.
Okay?
Please hold on. Give me 1 minute. I added to the chat the link.
Okay? All right.
And by the way, I'm a big fan. I listen to your podcast, Rule of Law Radio.
3-speed or single speed?
Oh, what was that?
3-speed or single speed?
Oh, what do you mean single speed?
Fan.
Oh, 3-speed.
Okay. Speed regulations. Safe and appropriate speeds at certain locations. Prima facie speed limits. You know what prima facie means, right?
No, I'm new to this.
At first glance.
Or on its face, or first impression. In other words, this is a lawful speed until you prove differently.
Okay.
So, the speed is lawful unless you can prove that you did operate a vehicle at a speed greater than is reasonable and prudent under the existing conditions. Well, what constitutes reasonable and prudent? That statement is 100% subjective. What's reasonable to me may not be what's reasonable to you. What's prudent to me may not be what's prudent to you. Therefore, it is subjective, right?
Yes.
So, how would you prove that the subjective reasonable and prudent became an objective unreasonable and unprudent?
Good question. Maybe get the camera from the police officers.
Well, let me tell you. Look at subsection F on the screen here. What does it say?
It says the speed causes a person to fail to maintain control of the vehicle or stay within a single lane of travel.
So unless that happens, none of the above is true.
Okay, great. Yeah, it didn't happen. I stayed in my lane. There was nothing. I didn't swerve or nothing.
Okay. Where do you have a copy of your citation that you can post?
Well, again, you never rely on what's on the citation. You always go by what's in the complaint. Unless your law specifically allows the citation and only the citation to be used as the complaint.
I see. Where do I have to go to the courthouse to see the complaint?
Yes, you need a copy of it.
You do.
Okay.
And that's,
in other words,
and that's what happened to me. Look at the
someone tell him the rules on checking the court record.
Yes, just what I just said. I forgot to actually look at the real folder inside of the record, and that was they pulled that on me. They served me with one document, and they filed another. And I would have caught that if I actually looked in the hard copy of the file, which I should have known way back in the day because I was meticulous at that, but I forgot.
Well, let me interrupt. Yep. That's what Sandra did wrong. But now my question for the group to answer and inform him is, what are the rules on checking the court file? Not how you screwed up by not following them, but what actually are they? And this is why you fail to do them.
And it is to go in and check the file every week to 2 weeks up until about a week before the case, and then check it on a daily to every 2 to 3 day basis.
Okay.
Well, okay. Sort of correct and also not correct. The closer you get to the date of a court appearance, the more often you check the court file. In the beginning, you can check it every week to other week. Okay?
Okay.
But the closer you get, especially within the last 30 days, you increase the frequency. The last 30 days, week 1, you check it Monday and Friday.
Okay.
Week 2, you check it Monday, Wednesday, and Friday. Week 3, you check it Monday, Wednesday, and Friday. And week 4, you check it every single day up until trial if you are in a position to do so. But under no circumstances do you ever fail to check it as early as possible on the last business day before your trial.
Okay. Understood. Understood. One more question for you, Eddie.
Go ahead.
On the site, on the law, on the link, on A, B, C, and D, E, and F, do they have to prove those? Is that the part of the due process they have to prove for each point that I violated, or just F?
Okay. The way this reads, A, B, C, D, and E are independent of each other. They are ORs. Approaching and crossing an intersection of railroad grade crossing, or approaching and going around a curve, or approaching a hill crest, or traveling upon a narrow or winding roadway, or traveling in, through, or approaching other hazards that exist due to pedestrians, other traffic, weather, or highway conditions, and the speed causes the person to fail to maintain control of the vehicle or stay within a single lane of travel. So F must be tied to at least one of these things here in A, B, C, D, E, or E.
That makes sense. That makes sense.
So all of these are ORs, while the last qualification for F is an AND. So it must be one of these things I've highlighted and F in order to be an offense. That's the only way they can prove that you are operating at a speed greater than is reasonable and prudent under the existing conditions, and that you failed to give regard to the actual and potential hazards then existing.
I see. There was a construction crew redoing the freeway when I was right by me when I was pulled over.
That was right by you. Did they charge you for doing it in a construction zone?
Yes, yes. The construction zone shows 60.
Okay, again, do you see construction zone in this?
No, I do not.
Okay.
But it says it says highway conditions.
Yeah. But it also follows and. Look, A is the general declaration, okay?
Yes.
It's general.
Okay.
In a general sense, this is the way this is what the law is. But in a specific sense, each of the things I've highlighted plus F is what the law specifically is.
Got it.
Specific always overrides general unless the specific section of law says otherwise.
Understood.
Okay.
You just made me you got a smile on my face. I'm glad to hear the good news.
Well, again, look down here at number 2, 3, 4, and 5. Subject to subsections 1 through 4 and sections 41A. So there's 2 other sections you've got to look at, possibly 3 other sections. Let's see what these 2 are. The following speeds are lawful: 20 miles per hour in a reduced speed school zone, 25 miles per hour in any urban district, and 55 miles per hour in other locations. Except as in provided 604, so 604 is a 4th one we'll need to look at. Any speed in excess of the limits provided in this section or established under section 602 or 603, which are the two that are up here, is prima facie evidence that the speed is not reasonable or prudent and that it is unlawful. But again, this is a general declaration that still requires F to be true for it to apply.
Oh, great. Okay, I understood.
A violation of subsection 1 is an infraction, not a criminal penalty. For an individual convicted of a speed violation, then it should say found liable, not convicted. Where the individual is operating a speed of 100 miles per hour or more, the court shall impose a fine not less than 150% of the suggested fine in the uniform fine schedule authorized in section 76-30 or -3-301.5 and in effect at the time of the citation. So, let's see if any of these other sections deal with a construction zone. State highways. Let's see if the word construction is in here. Okay. The Department of Transportation, this is 2. The Department of Transportation may establish different speed limits on a highway or section of highway based on highway construction. Okay?
Okay.
So, they can change the posted speed limit. But that does not change the requirements for how you violate the speed limit as being reasonable and prudent.
Yeah, it was a sunny day, by the way, and it's a dry road.
The statute doesn't say jack shit about the weather.
Okay.
Okay? Do you see anything here about road conditions?
Let me see. No.
Yes, you do. Right here. Weather or highway conditions.
I'm looking at my phone because I'm at work.
Subsection E, weather or highway conditions. But again, regardless of it, the weather or highway conditions, what must have happened is F. F must always occur in combination with A through E.
Okay.
At least one of the things in A through E.
Okay. Understood. I got one more quick question before I got to go back to work, Eddie.
Yes.
Do I have a right to a public defender for a traffic court?
It's an infraction, so I doubt it.
Okay.
If they could send you to jail for it, yes. But if all it is a fine and it's not being prosecuted as a crime, no.
Okay. That's what I thought.
Okay? So we found where highway construction is relevant, but it doesn't change how what is reasonable and prudent is determined.
That's true. I understand.
Okay?
Thank you, Eddie, for the help.
You're welcome.
Know all that you do.
All right. Have a good night.
Bye.
Bye. Okay. So, given that, anybody else got anything in the last 15 minutes we got left?
Question in relation to a constitutional challenge. Do we use it all? I believe it's Article 3, Section 2, that if the state is a party to it, that the Supreme Court has original jurisdiction. Is that of any use at all to us, or is that?
No, it's not.
Okay.
Any other questions?
Eddie, I'd like to ask a question to set up just my mindset for the next class next week. I'm going to put the money in soon, but I'm still on the road.
Okay.
So I took your advice, and last time you harped on me pretty hard to make sure I knew all the laws regarding the DA's office, first appearance stuff. So I looked them all up. And the last comment was a nice segue into that if it's a criminal, if you can do jail time, then you are entitled to a defense. An attorney. Now in Colorado,
if you cannot afford an attorney.
Right.
Remember, that's always the way it's couched. If you cannot financially afford an attorney, then one will be provided to you.
Right. So, but we were talking about these plea agreements that are forced upon us with no judge, and then, we talked to the DA first. Okay, so the screening was coming in, and I needed to make sure I made my argument against the recommendation of the magistrate. And I looked up all the laws, and what was crazy is I actually read in detail the bill that went through in 2013 to amend the law in Colorado specifically to that. So apparently before this, the DA could talk to you without being represented, but it was still in the context of judicial oversight. That's the part they were missing. But this El Paso County was using that language to twist it into a first appearance without a judge or representation to try to pressure you into a plea agreement. But in 2013, they specifically said, if it's a petty or misdemeanor, you must have counsel. And the DA knows this. He must not talk to you without counsel. And that's still, so they're still doing it. So I spelled it all out, and lo and behold, the head district judge of the federal court here basically said the magistrates go scratch. We're not, they rejected their argument. So now the case moves forward. I get to serve the DA's office, and that's what I'm trying to set myself up properly for these next steps, because this is a door that rarely gets cracked open.
Okay. Well, glad I could help that far then.
Yeah, I mean, I took it. I read. I spent several days reading it. So I don't think anybody's seen all those laws stacked together, at least not in a very long time. And so the federal court said, hey, we're actually interested in this. Why is that county doing that? Or they're giving me a slight thumbs up because they're also the same judges in the police suit. Because they're somewhat related, they gave them the same judges both cases. So either way, it doesn't matter.
That could very well be a good thing.
Yes, I think it is. The magistrate judge I have in the police suit, super professional, super polite, super supportive. I'll be meeting with him on February to give him a status update. I'm assuming I've got to get the parties served. Usually, because it's important.
Here's something else you need to look at. The law that they created that takes away qualified immunity, you need to see if that law also impacts prosecutorial or just public official immunity in any other way. Not just cops, but anybody.
Well, the suit I was just speaking about was all about prosecutorial immunity. And the magistrate judge was arguing that, all prosecutors are immune because that's their title. Prosecutor equals immune. That's not how it works. So I spelled out all the law, spelled out how the process is, how it's supposed to work within a judicial process.
Exactly, but here's the difference. By going against what the law required him to do by having counsel present for anybody he's talking to at that first appearance, he is not acting in his capacity as a prosecutor.
Exactly.
Because he is not acting in compliance with law to perform the duties of a prosecutor.
Exactly.
So he doesn't have that prosecutorial immunity.
And that's pretty much what I argued, yes.
Yeah, and so that's where the judge fucked up by even trying to draw that conclusion. And that's probably exactly why the federal court is willing to take it.
Well, this is the federal court. It's a federal magistrate judge who was recommending it wasn't taken. But I think in a way it's a bit of a backed in the corner because of the nuances of what are happening. They've created a process that is not legally, like you said.
Well, they created a process that's unconstitutional and in violation of state law.
Exactly. And that's pretty much the premise of the arguments. So, however it came together, and thank ChatGPT, but I mean, I found all the laws, but however it came together, it got their attention. So, next steps, because this is something, we're in federal court.
Wait, let me interject one thing. You did not use any case law provided by ChatGPT, did you?
I vet everything.
Well, by vetting, you actually went and found the exact quote ChatGPT gave you in the exact case ChatGPT gave you and found it to be relevant on your own. You verified.
Every single time. I've been doing this for 2 years. Yeah.
Don't fail to do that ever.
GPT's better, but it still gives you shit sometimes. I know. No, I went back and we vetted every single case. We vetted every law, and I vetted every case that the magistrate judge also quoted, which was interesting.
Well, just FYI, one of the criteria I put into a request when I ask it to do legal research is that it must return a case found on a reliable, authoritative online source, and it must provide me with a direct URL link to that case on that source.
Yep.
Always make that a part of your request when you're asking for legal research from an AI engine. Always.
I generally do that, and then once I have my filing done, I go through and I highlight all the case references, and then I actually ask again for the URL, and we go through the law, and I read it, and I make sure it's verbatim. I always do that on my final screening, just in case I missed one.
Yeah, that's the reason why in my pleadings I hyperlink all court opinions. That way I can put the link. I do that with the statutes too. Every reference to a legal authority, I put it into my pleadings as a hyperlink. That way, if I need to refresh my memory, all I have to do is click the hyperlink, and it takes me right to what that section's about, and I know what I'm arguing and why.
Do you leave the hyperlink for the court?
Yes. All it is underlying text as far as the court's concerned. So it's just considered an accent. It doesn't change anything about what the court gets.
But the court can open that document too in their digital file and
yeah, but that depends on whether or not it's submitted as an actual Word document or just a scanned image of the Word document. While they can read it, they can't necessarily click on it unless it's been OCR'd, which wouldn't keep the link in place. It would keep the underlining and the highlighting of the text in place, but it wouldn't keep the URL if it was first scanned in as an image in OCR. So the only way the court could click on that URL is if it's actually filed electronically as a Word or PDF document.
Well, that's what we do in federal court. We file it electronically.
If it's filed as a PDF, then that helps the court, and the court loves that shit. Anything that prevents them from having to go find it on their own and get out of their fucking chair to find a book, they're happy.
That's awesome idea. That's awesome. I'll do that from now on. That's great. Okay, because normally I just quote the language and maybe make a reference or something like that, but that's good.
Yeah, well, see here, I'll show you real quick how I do it so that it works in the best way possible. See, the statute site here in Texas, you can actually do word searches when you're looking for stuff. Okay. Let's see. So let's say I go. Everybody can see the screen, right? All right, select a code. Let's say we're looking for the transportation code. And we want to search for specific text. Okay. Let's see. Oh, they've changed this up. This is find a statute, select a statute, search a statute. There we go. Search across the transportation code. And find me where the term magistrate appears in the code. Okay. Now, let's say that the section I want is Chapter 543. Okay. So I open that, and you see where everything is highlighted, right?
Yeah.
If I copy this URL, that's the same way it will come up when you click the document, is this highlighted text. That will allow the judge to see exactly what you were looking for. So when you're making an argument that's relevant to a specific term, this is the way I copy the link to do it.
We had an argument specific on this and one of my motions about how the cop refused to take me to the magistrate immediately.
Correct. But there we wanted them to read the whole statute, so I made a link to the number of the statute. Don't put the URL on the entire text of the statute. Put it only on the numbers of the statute. And let me show you something else I do when it comes to that. Let me get Helen's pleading open here. All right. Okay, you'll notice that right here, this is how you do it. However, in all my new pleadings, I put a link to 547 by itself, which is just the chapter. I copy the link to the chapter 547. Then when I want to go to 60 or 302, I put that as a separate link for just the 302. That takes me specifically to 547.302 and not just chapter 547. Then for the subsections, I go and I copy the text that appears in that subsection, and that's what I make for my link for A. And then for C, I do the exact same thing. So I've actually got 4 separate links right here. And the A and the C would show the judge exactly what terminology I'm searching for if they click that link.
Nice.
Okay? So that's the way I do it. That's the way all of the new pleadings and the new seminar material will do it. Okay? Now, Helen, this is what I was talking about. This is the specific paragraph where we make the argument that the complaint alleges at least 2 lighted headlamps on each side of the front. And that's language that does not appear in the statute. Got it?
Thank you. That's the main point.
Chris, how'd you get whiteboard control of my screen?
I have no idea. It's just messing with my screen too.
Yeah, because I didn't turn that on. So I don't know why it's doing it. Okay, but in any case, there you go. That's how I'd recommend you link the statutes. The individual parts of the statute number and the statute sections. And you do it differently by doing specific chapter and section searches and then specific text searches for subsections and sub-items.
Okay.
Okay. For instance, if we go to A, all right, which is this one here, the text I would have searched for was a vehicle shall display each lighted lamp. That would have been my text search. Okay, and for C, I would have put at least 1 lighted lamp shall be displayed. That's the text I would have searched for. And those would have been the things that came up highlighted when I clicked on the A or the C respectively. Got it?
Okay. Yeah, that's great. I think the courts will appreciate that.
Yeah, it makes it a whole lot simpler for them if they've got an electronic copy of the pleading that they can interact with. It will help them understand that you understand what you're reading and understand what you're arguing about, because here it is right in front of them from an official source.
Okay. Well, so can you give me some next step homework just to think about, because I got to serve the DA's office, and then it's going to move forward like a normal case. They're actually going to move they're going to probably do a 12B6 to dismiss. But the attorney in the police case,
but they're going to ask to dismiss based on what?
Who knows? Probably
we'll take a wild guess.
Immunity, absolutely.
Correct. Yeah. Since you know that, what do you need to prepare to argue against?
Well, I've already done it. I've spelled out all the law.
No, you've done it to get it through the process to allow it to continue. You're still going to have to argue it at trial. Okay. If you've already done that and it's already been approved to proceed, then how are they going to argue it again? They've already lost the argument. So if you're saying they're going to argue to get it dismissed, it's got to be, where are they going to get an opportunity to seek dismissal again?
Well, again, this is the good thing, in my opinion, about pro se IFP processes and form of pauper screenings, because once the court makes an argument for the defendants, isn't that already raised, or do the defendants get to raise it again?
Well,
because the court stepped in sua sponte and said this DA has immunity.
and you're
I'm
appealing that. So now they're going to file it for your appeal.
Well, no, the court hasn't even started. I got through the screening process. My case is now allowed to go forward.
Okay, but you misunderstand what I'm saying. The judge can't say he has immunity and then say you can proceed. Those are contradicting statements. So which court said he's got immunity and you can't sue him versus which court said go ahead and sue him?
It's the same court, but there's a magistrate judge who screens cases for pro se's if you're in forma pauperis.
Okay.
He allowed the police suit. He actually spelled out what he wanted for the police suit, and that one went through very easily. This one, he put up every wall he could.
Same judge?
Ironically, the same judge, yeah.
Okay, all right. So, but because he's relying on the premise of absolute immunity for prosecutors.
Yes.
But what he hasn't done is compare that to what state law says the prosecutor cannot do in his official capacity, which would deprive him of the immunity of a prosecutor.
Which I spelled out per your recommendation. I went through every law and I pulled every law. Therefore, my objection to his recommendation was what got this thing passed. So there's another that the head judge, screens the arguments between a recommendation and objections, and the head judge sided with me.
Okay, so now it's going to So that's the screening process, which means it goes where now?
Well, now it's an official case. I serve the defendants. They answer.
So the screening process is actually a determination as to whether or not the case is allowed to proceed, because I must presume that the defendants filed a 12B6 opposing the acceptance by the court.
No, the defendants don't even know the case exists yet.
Oh, okay. So you filed it and they screened it before anything ever got actually filed as a case.
Right.
Okay, then yes, they're definitely going to file to challenge it on immunity grounds.
Okay.
And what the lower court said to get it into the court is irrelevant to you having to argue it again. You're going to have to argue it again.
Okay. So I'll dig into, since this is federal, but it's highly related to the state level, I'm going to probably go back further into more federal.
You're arguing a violation of federally protected rights by a state prosecutor's refusal to comply with state law and the protections afforded to those federally protected rights by that state law.
Okay. Yeah.
Because what the state actually did was codify the protection of the right to counsel in such cases, and the prosecutor ignored it.
Yes.
Okay.
Yep.
That's the argument.
Okay. So we just treat this as a normal case. We're going to serve defendants.
Now you do. Yes.
Okay. All right. Well, I'll read some more up for this next week when we get to class, because I definitely want to make this a big enough argument for not just the 10th Circuit, but the 5th Circuit, and et cetera, you know? I'd really like to use this case, if I could, to make it a bigger thing.
Well, yeah, I'm trying to write a suit based on Randy's arguments if he would learn how to write an actual suit. But I'm trying to write one that does the same thing here in Texas for the examining trial. Because what you're talking about, the prosecutor doing, is avoiding the examining trial and acting outside of judicial review, which he's not allowed to do in a criminal matter.
Yes. And that's pretty universal across all states.
Exactly. But the laws that protect it or govern it are different. Some states codified that protection, some didn't. Texas did, and the courts ignored it. Not just the prosecutors, but the courts in general, statewide at every level, have ignored it.
Well, this case in this law in Colorado actually specifically had the discussion and language of being in alignment with SCOTUS's. I don't have the cases in front of me, but SCOTUS made a ruling that if it's a petty offense, misdemeanor, you are entitled
to counsel.
Yes. If it's prosecuted as a criminal case, yes.
Yeah.
Okay.
And
But did they define what a petty crime is?
I think so. I can't specifically say, but
is one of the criteria that you could be sentenced to jail as part of the punishment.
Yes.
Okay.
Yes.
There you go. Which means not all petty crimes are covered.
Right, and that's where you get into the state's definition of what a petty crime is. And
exactly.
Right. Right. Well, in Colorado, it's pretty clear. Petty crimes up to 10 days. It used to be 6 months. Now it's 10 days in jail. So, all right. Well, thank you.
Yes. All right, guys. I hope everybody enjoyed the class tonight. I hope it was enough to get people willing and able to join up, and let's go through this and get you on your merry way to learning what you need to know and get this done right, so that you don't wind up drowning while you're learning to swim. Okay? And I'll give you a heads up. If you wait until you have a problem, you will never, ever be prepared to deal with that problem in time. So keep that in mind when you're making a decision about whether or not to be a member of the class. All right, that said, y'all have a great weekend. Good night. Happy New Year, everybody. I hope it was been good so far. Y'all take care, and I will see y'all next Thursday.